Hey, what's up, guys? Welcome. Am I muted? No. Welcome to Lawsplaining the Interwebs. I am your host, your terribly late and ultra gay host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And how can anyone possibly call me anti-LGBT when I am gay so often? So, what's up, guys? How are you today? We've got a big, another big document. It's actually around the same size as the other document that we're going to get to today. This document has some places that are a little rougher around the edges than the other document. I have theories as to why, but it's not, again, it's not my job to apologize for anything in the document. So I'm going to point out where the errors are. And for whatever reason they're in there, doesn't really matter, right? Because at the end of the day, they're filed with some errors. Are these errors fatal to the document? No. Might the court ask for clarification from the party on one specific error? Very possibly. Very possibly. Won't really know until, for now. They may do it, they may not. And we'll have to go ahead and watch for that. Okay, housekeeping stuff, and then we're gonna get into this document. Tomorrow is a very busy day for me. Tomorrow, heel versus babyface. I will be on his show at noon Central Time. He will be teaching me to paint a mini. I have a Scarab Terminator, a Thousand Suns Scarab Terminator. And he will be teaching me hopefully some painting techniques and giving me some ideas on how to do that. I assume we will be talking Warhammer and other stuff in nerd culture while doing the stream. I'm really looking forward to that. So I will try and tweet out the show link as soon as I have it. But that will be noon tomorrow. Okay, after that will be Live Chat Wednesday in the Discord. Live Chat Wednesday in the Rekieta Law Discord. So, if you want access to the Rekieta Law Discord, the best way right now is to, on Patreon, pledge $5 or more. And have your Patreon linked to your Discord, and it will automatically put you in to the Rekieta Law Discord. That's the best way to do it. It's the easiest way to do it. It is the least maintenance way to do it. It will cause everybody, me, you, my poor moderators, the least amount of headaches. So that is the method. The other way to do it is a little bit more complicated, but also acceptable, is to subscribe to the YouTube channel at the Super Lawyer membership tier. If you want to do that, that is also great. You're also welcome and very appreciated. Okay? But the Patreon is the preferred method to do that. And at the $10 level, you can participate by voice in Live Chat Wednesday. Everybody can participate by text, but sometimes it's a little easier to participate by voice. And you can listen or whatever. And then that's Live Chat Wednesday. And that will be tomorrow after Heel versus Babyface's show. Now, I don't know exactly how long his stream with me is going to go, but I'm budgeting normally 2 hours to the stream, which means that the Live Chat Wednesday should start around 2 p.m. Wednesday Central Time, which is the normal time that would start. However, it very likely will be later tomorrow. I'm just trying to prepare people. Usually it's at 2 p.m. on Wednesday. I'm guessing it will be a little bit later tomorrow because of the stream. That being said, that will be fine. Now, tomorrow night is not, I repeat, is not another document in Vic Mignogna's case. Tomorrow night is also not at 11 o'clock. I know it is crazy town. Nothing is going right. Doggos and cattos are eating each other and then being friends or whatever. Tomorrow night, 10 p.m. Central Time, 1 hour earlier. will be the Russell Greer stream with Sriracha. That is the easiest way for Sriracha and I to be on the same schedule, is to do the show an hour earlier. And I wanted to make sure, as the person who introduced me to the wonder that is Russell Greer, I wanted to make sure that Sriracha was there for the show. And so it will be at 10 p.m. Central Time tomorrow. We will be talking about the latest antics of Russell Greer, along with a very old antic, and that was him getting arrested in high school, something that he tries to downplay. So that will be tomorrow. Thursday, we will be back with Monica and Ron's reply document. That will be Thursday. Friday, I wanted to do a Chad Dad show, but one of my founding Chad Dad members is not available, and so it cannot happen on Friday. So Friday's show is coming together. It will be announced as soon as I have it figured out entirely. But that is the rest of this week. I wanted to make sure and keep people on the up and up to the goings on. But we will be doing something, very, very soon with the Chad Dad show as soon as all of them are available. I only want to do one of those shows without Larry and Doug are the founding Chad Dad members, me, Larry, Doug. And so if one of us has to be gone for it, I want it to be because of an emergency, not something we could schedule around. So that's that. A big brain panel is possible, or just watch parties on Twitch are possible. All sorts of things are possible for Friday. I'm not 100% sure. I may give this channel a break on Friday, Saturday, and Sunday, to do stuff on the Rekieta Media channel. That said, I've got to do a thank you. I got to do a thank you here. This is Brian. Brian, who I don't like using last names. He will know who he is. I talked about this on the show with Dan Fraga. And it's this comic. What if Wolverine battled Conan the Barbarian? So I talked about this. This is a comic I had a long time ago. I really, really enjoyed it. But my copy got absolutely mangled. It got absolutely mangled and chewed up and demolished over the years. And so I had lost it. But now I have a very good condition copy, and I'm really, really thankful. It is an awesome one. Thank you so much to Brian. One more thing before we get fully started. This is a preview for the other channel. There will be a video. I'm also trying to have 2 videos come out tomorrow. One on this channel, one on the other channel. If you're not aware, Keemstar won his lawsuit. I should not be in 720p. I am. What the? I guess I changed it to 1080, but then it changed to 720. So I don't know. That's really annoying. So I'm sorry. We're in 720p. Okay, Keemstar won his lawsuit against Romeo Lacoste, which, based on the filings, he absolutely should have won. Doesn't matter how much you hate Keemstar, which is fine. Go ahead, hate him all you want. That's not my business. He won against Romeo Lacoste, and that we will have a short video coming out tomorrow detailing the pretty short opinion of the judge. It doesn't need a full live stream to go through it, so I will hit the main parts of that in a short video tomorrow. And then this is the short video I want to do on the other show tomorrow. I bought this like a year ago. And I finally got it. My full-size Intercessor Primaris Marine from Games Workshop. So it's still wrapped up. It's still in the plastic. I'm gonna do an unboxing and look at it on the other thing tomorrow because I've been waiting for this thing forever, and I finally got it. I don't know why it took so long. That is a weird looking vibrator, but you know, I hear it's powerful. So lower resolutions, my friend. Ouch, fam. Ouch. I just hope everybody can read the text. That's what I actually care about. But yeah, so that's hopefully coming out tomorrow. I'm gonna try to get both of those videos done. And now, without further ado, we should probably go ahead and get into this document. Now, as a preface, I'm going to preface each of these documents a little bit. And you obviously, if you're here, I hope you know my bias. I am pro-Vic. I have a pro-Vic bias. I want him to win. I'm reading this as objectively as possible, but undoubtedly, I'm looking at arguments that are favorable to Vic. So let me try and mitigate that bias. I know most of you know that, but if in case there's someone who's catching this at a later date who's not familiar with me or my show, I don't want any sort of illusions about where I stand or anything like that. I am pro Vic and pro the arguments in favor of Vic. That said, these are appeals. And like I said yesterday, and we'll say again tomorrow, you're asking, or say again on Thursday, you're asking a group of judges to look at the work of another judge and say, not good enough, and turn it over. To say, nope, go back and try again. That is, without question, a difficult task for anybody. So, while I think what I've read so far is sufficient to do that task, I don't know that it will happen that way. So I hope it does. I really do. I think even in the briefs, the initial briefs, and then supplemented fairly well by these replies, I do believe they have put forth a compelling case that Vic was not given the appropriate shake at the TCPA hearing and with the TCPA documents. And if that is the case, then it should go back to the court for a trial. I think that has happened. You guys may disagree and you can come to different conclusions, obviously. But even though I think they've done it, the prospect of overturning the trial court is a low prospect. And that's important to remember. Don't want anybody out there thinking that I'm saying this is a slam dunk, this is an easy thing, this is a sure deal, or even a very likely outcome. It's a possible outcome, and it's the one that I think the court should come to based on what's in the documents. Will they is a different question. So that's that. I also heard that I don't do enough show prep for these streams, so I did even less today than I normally do. Because normally I would pour a glass of whiskey earlier. Just kidding. Okay, super chats, and then we are go. Let's see. NGE fan 76 says, "Hey Nick, just registered to take the LSAT in November. Any tips for studying for it or tips for applying for law school after being out of school and in the workforce for a few years?" Yes, couple things. Studying for the LSAT is merely go download sample LSATs, have someone time you and do it, and then score yourself. And then do it again a couple times. You should, the LSAT tests how your brain works. It's not about your knowledge. It's not about what you've learned. It's about how your brain functions. And so you can figure out how good you're going to do on the LSAT by taking the past LSATs. You'll do probably pretty comparably. There are classes you can spend a bunch of money learning how to take the exam. It's literally teaching the exam and exam taking techniques. My biggest mistake when taking the LSAT was that there was one section and one problem that I spent way too much time on, and it caused me to not have time to fully finish out that section. And unfortunately, that was the graded section. There's 5 sections and they grade 4 of them, or 6 and they grade 5. I don't remember. But that was one of my graded sections. Had that not been in there, I would have had a fantastic LSAT score. Instead, I only had a very good LSAT score. So them's the ropes. But that's how it goes. But it's literally about how your brain works and how your brain processes logic problems, and reading speed and comprehension. Don't waste a bunch of time on the test on individual questions. Just skip it. They say just skip it and move on. They mean it. You're much better skipping one than having to skip 7 or 8 questions at the end. As for applying to law school, very simple. Send in your application to the law school. Wait a couple days. Call them if they're close. Call them and set up an appointment to meet with the admissions people. Ask them about the school. Go in and remember that they're selling you the school. It's your money. It's your money, or it's scholarships that you are going to get that's going to pay for it. Either way, the money that they get is from you. You're the customer. They're selling to you. You're not selling yourself to them. If your scores are good enough for your GPA and your LSAT to be anywhere within their requirements, from that point on, they're selling you. The hard part is getting unanonymous, right? That's the thing with online applications, is you are anonymous. So call up their admissions department, schedule a meeting, say you'd like to know about the school and what they have to offer, and then go in and be very polite, dress professionally, and talk to them. Tell them your story. Then when they see your name on the little document and they're ready to stamp approve or deny, they go, wait, I talked to this guy. I talked to NGE Fan 76. That was a nice person. Interesting life story. I really liked them. They were polite. They came across well. Approved. That's it. Go do that. Also, being in the workforce for a few years is in my opinion, should be a requirement for law school, rather than going directly from undergrad into law school is ridiculous. I don't know how you're supposed to coach someone through a divorce or a job transition or anything if you've literally been in school your entire life. I don't know how that. Yeah, here, let me probate your grandfather's will. I have never had anyone in my life die that's near to me before, because I'm only 25, right? Like, no, thank you. Please give me someone older. Mr. Armageddon says, hey, Nick, not sure if you talked about this recently or not. Can you give a brief breakdown of what comes next in appeals? Oral argument, something else. What comes after that? Finally, rough ETA on judgment. Oral argument. If the appeals court wants to allow oral argument, that will be sort of the next phase. Technically, Monica and Ron have the ability to file a reply brief on their cross appeal in the next 20 days from the 19th, unless they get an extension on that. There could be, like I said, it's very possible that the Court of Appeals will have a problem with this document in particular for one section. And if they do, they will probably give Vic's team 12 to 72 hours to remedy that and refile. That being said, then they would schedule oral argument. When will that be? It's at the pleasure of the court's schedule. There's no way to know. But that's how that goes. What they will likely do is wait until the briefing deadline for the reply brief for Monica and Ron, which, like I said, is a 20-day window from the 19th. Unless they get an extension. Or they could simply say, we have no interest in replying, and they can go on. The reply briefs are optional. They don't have to file them. So it's impossible to know at this point when the next thing is. Also, Research Texas courts and the second District Court of Appeals in Texas, their websites have not been updated since the 28th of April filings. So that means that they don't even have the May extension that set June 19th as the date for the as the updated date. They don't have any of that in there. They don't have the new filings in there. So we don't know when that will be. As soon as I know, I will let you know. ETA on judgment. I mean, it could honestly be another 90 days before anything happens in this case. And then if they do oral argument, it could be 90 days plus after that. It's entirely at the mercy of the court. Plus with COVID, you've got a bunch of stuff that didn't happen for a while. And that is going to push everything back. So who knows how long this is going to go. I wish I could give you better answers. It would be great to see judgment on this by the end of the year. That would actually be fortunate, but it's likely going to go into next year, depending on the briefing. Bad Vibes says, Rekieta Law, straight and timely? Shenanigans. No, it didn't happen today. Fox McLeod says, Monica Rial and Jamie Marchi are fat. That is all. It was so on point. It just hammered it home right there. Let's see. Next is Decker Ramirez says, assuming this case went to a courtroom, I have two questions. One, how likely is Marchi to be deposed on video herself? Marchi will be, I mean, if this goes back on appeals, if it is sent back to the lower court, Marchi getting deposed is like a 99% probability. Whether she is a party, even if her stuff is dismissed, it is extremely likely that Jamie Marchi will be deposed as part of this. She's in Texas. She won't have I believe she lives in the same area that the court services, and so she won't have any way to resist jurisdiction on that, and she will likely need to be deposed. And I would think Vic's team would really strongly want to do on video. Seems very likely. Whether that video will be available to the public will depend on a lot of things. Next, how likely, or at this point unlikely, would Marchi's depot be shared on this channel? If I can get my hands on it, of course I will share it. That's just the big if. It's not easy to get your hands on deposition videos. Reply when able. Well, I did, because I was. So, Zara BP, only moderators have access to links because we had issues with spam porn bots coming in and spamming links. So I prefer that the links that get shared by the moderators channel related. And unfortunately, I can't turn on link sharing for everybody because of the spam bots that come in and do so. So preferably, it's not really about the waifus and the lewdness of them. I don't particularly care. It's just off of the topic for the channel, and with most people being restricted to having links, the links that I would like shared would be ones that are related to the channel, related to guests, related to topics we're talking about. That's what the functionality is there for. So I hope that answers the question. Okay. But by the way, if you want waifus, there's a not safe for people section of the Discord that is loaded with waifus, both lewd and non-lewd. So you guys can want to do that. It's there. That's a soul crushing section of the Discord. Here we go. Mildly offset. Here is the document. Now, something to note about this document. And I believe this was the same for the Funimation document. But the document that was initially shared on the internet here is not the correct version of the document. Although, to be fair, I've only found one significant change in the document. So I'm not saying that there's a bunch of stuff that's going to change in the body of the text, but the part that is changed is very, very important because it was missing in the shared version, in the shared version, it was missing this from the certificate of compliance. It was missing the word count. It was missing the word count. The word count is a formal requirement of the document, and so it was criticized for missing the word count. However, they actually caught that right after filing and refiled the corrected version at 11:58 p.m. I think the original was filed at 11:55 p.m. So 3 minutes later, they filed the updated version with the word count included. The thing that you have seen on Kiwi Farms, and the thing is my camera causing trouble. It's a little bit. The things that you may have seen on Kiwi Farms or on Twitter were not actually reflective of the filed document in regards to the word count. Hopefully that helps. But they did go ahead and get that filed under the deadline. Now, I'm not going to say that the people sharing the documents would have known. They absolutely would have known that the corrected document was filed 3 minutes later and chose not to share them. I'm not going to say that's nefarious because it may not have been. They may have just, oh, well, I have the document. Here's a sharing. But I just wanted to point that out, that is the issue. The word count issue is resolved. It is not the only problem with this document. And to my knowledge, nothing else was changed. But I just want to point that out. Does my mic keep cutting out? I can fix that real quick. Okay, there. Just in case it was cutting out, I did have the noise gate up higher for one of the streams I did with Drexel. Okay. Here we go. Let's normally I skip the table of contents and table of authorities because they're boring, but this is the source of what I believe is the most glaring error in this document. And I'm sure there's a reason for it, but the reason ultimately doesn't matter. It doesn't look good. And is it fatal to the document? No. Might the court want it fixed? Maybe. They really might. And that is the table of contents. The page numbers are wrong or missing. Same with the table of authorities. And this is a nasty omission. And I would guess it had to do with coming down to crunch time and having different formatting happen between exchanging with people or something with edits and stuff like that. Page numbers get changed and they just didn't get updated. But I don't know. And again, it doesn't really matter what the reason is. Doesn't look good. So here is the missing page numbers, and there's some here, but they're not, they're missing in this section. And then in the table of authorities or index of authorities, they're missing here as well. So that's a problem. Does it mean that the appeals court is going to reject the document? No. If they did, they would probably give them an opportunity to cure. But like I said, I'm not here to apologize for the document. Those are issues that are in there, and it's a section I would normally skip. So I don't want to be accused of glossing over that. We point out issues when they show up. All right. Issues presented. Evidence before the trial court did not support its determination that Vic was a public figure. Vic sufficiently established by clear and specific evidence a prima facie case for the essential elements of his claims against Marchi. The evidence admitted at trial was insufficient to establish Marchi's affirmative defenses, and 4, the trial court's award of attorney's fees and sanctions against Vic constitutes reversible error. And again, that's going to be predicated on the idea that Marchi should not have been dismissed from the suit. Reply to the statement of facts. And we saw this in the last section, the last document. Again, this is where they're going to call out errors in the statement of facts and just point out the other side's lack of candor to the court. Oh, I was thinking of drinking every time I run into an error. That could be funny or it could be not funny. I don't know. Since there was an error in the table of authorities and the table of contents, I will drink another drink, and then we'll drink every time there's an error. So we'll see. Oh, yes, and after the stream on Twitch TV /Rekieta Law, we will be doing a watch party of Hellraiser, and Lady Rackets may join us, but no promises on that one. All right. Reply to the statement of facts. Victor Mignana, Vic, maintains and refers this court to a statement of facts and appellant's brief. And Vic provides this reply to bring this court's attention to two specific instances, appellee Jamie Marchi's unsupported or unfairly distorted factual allegations. Forgot an of there. And to highlight the importance of certain critical facts. First, Marchi grossly mischaracterizes Vic's prominence. She represents to this court that Vic testified, quote, that he can hardly walk into a convention without being recognized. The testimony cited. Yes, the 1980s Hellraiser. Cites by Marchi reveals that Vic's actually... God damn it. Okay, this first section's an editing nightmare so far. Mainly these couple of sentences. Ugh. Whew. Whew. But, actual, they mean, testimony was exactly the opposite. He testified that people don't recognize him. Further, he stated that people attend conventions to celebrate anime, not Vic. Second, now that's pretty important. That's a pretty important misrepresentation. Second, Marchi claims that Vic admitted under oath to assaulting Marchi. Nothing could be further from the truth, and this is good. Vic did not admit to assaulting Jamie Marchi. Nothing even close to that. The testimony quoted directly in Marchi's brief that Vic touched her hair with his hand. Have you guys ever touched? I should do this with a lower alcohol liquor. Oh my goodness. You can see what's going on here, right? They're testing different words or editing in different words and failing to remove the other words. Are these errors, though? I have to stress. I'm gonna laugh at the errors. We're gonna make fun of them. Do they have any legal impact on this document at all? No, they really don't. They don't, because the court doesn't hang people on typos or editing errors. They may call them out. It's kind of rare that they do that, in all honesty. It's rare that they'll call out an editing error, and it's getting rarer. And this is a weird thing. As this has nothing to do with this document, to my knowledge, but as lawyers with various how do you say disabilities in the PC way? But people with like learning disabilities, or maybe disabilities that prevent them from typing effectively and stuff like that, as they are more and more coming into the profession, and every law school class has more and more people in that scenario, including people who get extra time to take the bar because of their various learning disorders or whatever. As that happens, the courts have to be more and more sensitive to the fact that this is part of the process, and that some people have issues with typing, and they really don't care that much for the most part. What they care about are the citations. They care about the legal arguments. That's the main thing. But like I said, we're gonna make fun of it. Okay, I gotta take a sip for Rand Touched. her hair with his hand does not support any assault. For one, it fails to show that the contact was in any way harmful or offensive. True. The testimony proves that Vic had no reason to believe it was offensive in any way at the time. Summary of argument. So we're through the summary, the fact statement. Number one, the trial court committed reversible error by failing to resolve all fact issues in favor of appellant Victor Mignogna, as required by the Texas Citizens Participation Act. Ironically, there should be a comma there. I think. Take a half sip. Appellee Marchi's response brief proves this. Vic established his claims against Marchi for defamation, tortious interference with existing contracts, tortious interference with prospective business relations, and civil conspiracy by clear and specific evidence. He also preserved any objections to Marchi's evidence. The trial court improperly excluded Vic's second amended petition and improperly awarded attorney's fees and sanctions. This court must reverse and vacate the trial court's order, October 4th, 2019 order and its final judgment and remand the case for final trial. Argument. So, criticism. This is not an error. This is a criticism that I have. And acknowledging that word count is an issue. Word count is an issue in these documents. You have a limited amount of words to make your claims. I feel like the Funimation summary sections were better constructed and a little more thorough. The summary sections aren't the argument sections, but they do help frame it for the court, and I thought they were done a little better in the Funimation section. But we're going to get into the arguments and see how they do here, because this is where it matters. The trial court, the evidence before the trial court did not support its determination that Vic was a public figure. The trial court's order includes a finding that Vic is a public figure, and therefore the trial court erroneously required him to prove actual malice. In a defamation claim, a claimant is either a private figure, general purpose public figure, or limited purpose public figure. General purpose public figures are individuals who, quote, achieve such pervasive fame or notoriety that they become public figures for all purposes in all contexts. Now, some people, initially when I read this, I was confused by this bracketing because it's not how I would think to do this. And so I didn't know what they were doing here. But I think on review that it might be the correct way. I don't know. I've never run into this problem in my own drafting. So some people are like, why is this bracket here? And I was thinking the same thing. But the bracket has nothing to do with the ellipses. The bracket is the removal of the S from becomes. It's the removal of the S. I think what you should do is probably just bracket in they become, because they was probably he or she, and then it was he or she becomes. So they become is the thing. I would just bracket in. I'm not going to call that an error. I don't actually know whether or not that's correct. But if people think that these brackets are here for a purposeless reason, which I initially thought, I was like, why the hell are there empty brackets? And it was looking at this and this together. It's, there were plurality disagreements in the rephrasing that they did to suit this case. So there's the reason there. It was a little strange to me. I wanted to make sure people saw that. Become public figures for all purposes and in all contexts. Limited purpose public figures are persons who, quote, thrust, like Neil Duckman, themselves to the forefront of particular public controversies in order to influence the resolution of the issues involved, ... inviting attention and comment, close quote, who, quote, inject themselves or are drawn into a particular public controversy, assuming special prominence in the resolution of public questions, or who, quote, thrust themselves into the vortex of a public issue or engage the public's attention in an attempt to influence its outcome. So there's that. Marchi's evidence fails to establish that Vic is either a general purpose or limited purpose public figure. To support her contention, Marchi directs this court to the following. 1. That Vic is a voice actor in the genre of anime. 2. That Vic is credited with over 356 productions in the website IMDb. And 3. That Vic voiced the title character in Dragon Ball Super Broly. However, italic and bold, I'm going to call that a mistake, even though it's not. It's a stylistic choice, but I don't like it in an appeal brief. I don't like that. I would do it from time to time, but I don't like it. How's that? On page 2 of Marchi's brief, when alleging these facts, she grossly mischaracterizes and blatantly falsifies the record. Have you guys noticed? I'm noticing so far that the language in this one is much more offensive. That is, on the offense, not making people offended. On the offense against Jamie Marchi. I mean, they're blatantly falsifying the record's a pretty brazen claim. First, Marchi states that Vic is, quote, one of the most ubiquitous voice actors in the anime genre, and in support of that contention, cites to Clerk's Record, Volume 2, page 1013. Specifically, Marchi cites the following. This is weird. They normally do their citations down in the footnotes, but they put that one in there. And I think it's because they didn't know how to do it as part of the sentence. So they had to kind of add it in, but it looks clunky. Now, real quick on that. There is no specific way to do citations in legal briefs. You can do footnotes. You can do inline citations. I prefer writing inline citations. I prefer reading footnotes. That's me. Okay. So question. Okay. Yeah. Your IMDb page says that you've been in over 356 productions. Does that sound? Answer from Vic. See, I don't even know. I mean, I said over 300 and I didn't even know. Now, Marchi's site is an outright falsehood and fails to support her assertion that Vic is one of the most ubiquitous voice actors in the anime genre. This is true. This is what they cited. Oh, I see. Sorry. This wasn't a citation. They were talking about the document itself. That's my bad. I unfairly criticized them. This is them talking about Marchi's citation from her document. But this is what is cited as saying he is one of the most ubiquitous voice actors in the anime genre. Now, there's no comparative table of credits. In fact, Monica has more credits, for example, I believe, than Vic. There's nothing to show the ubiquitousness of Vic as a voice actor here. That is a pretty bad misrepresentation. At bottom, Vic's job in the entertainment industry does not make him a general purpose public figure or a limited purpose public figure. I don't know what at bottom means, but okay. At bottom. So no, it doesn't. Second, Marchi states that Vic, quote, can hardly walk into an anime convention without immediately being recognized. And in support of that contention, cites to Clerk's Record, Volume 2, page 1014. Specifically, Marchi cites the following. Question. Answer. You're not recognized. How about when you're at conventions? Well, I mean, there, yes, because people come there specifically to celebrate anime. Okay. This evidence does not establish that Vic, quote, can hardly walk into an anime convention without being immediately recognized. Again, Marchi grossly mischaracterizes the evidence. And to be fair, that's not at all what this section says. It says that people sometimes recognize him at conventions. So, yeah. and that they don't recognize him anywhere else, which is interesting because they are making a general purpose public figure argument and ignoring the fact that he's saying you're not recognized out in public. He is not recognized as a voice actor out in general public. This would actually be a citation against the argument of a general purpose public figure. Considering the evidence before the trial court should not have required Vic to establish actual malice or gross negligence. And if that's all she put forward, then no, they absolutely shouldn't. I only had a drop. I'm supposed to wait to drink. That was my bad. That was my bad. Marchi claims that Vic failed to allege error about the trial court's determination that Vic is a public figure, thereby requiring actual malice on the part of Marchi. As a threshold matter, Vic cannot waive error as to his status as a public figure. So there's a citation here. Hoskins v. Fuchs is from the Texas Court of Appeals of Fort Worth. I don't know what the quote is, but they're saying that you cannot waive your public figure status. You don't have to preserve the objection. Marchi's claim that Vic has waived his objection to the trial court's finding that he is a public figure contradicts this court's recent opinion in Hoskins versus Fuchs. There we go. In Hoskins, a University of Texas Arlington professor, Fuchs. Am I being generous in calling him Fuchs? Am I being generous? Sued an individual, Hoskins, for defamation based on an accusation that Fuchs was having a sexual relationship with one of his students. Hoskins sought dismissal under the TCPA. Fuchs conceded at trial and maintained on appeal that he was a public figure. This court found that Fuchs was not a public figure anyway, noting that the issue was a question of law that could not be conceded or judicially admitted. Pretty interesting. Pretty interesting that they don't allow a concession for public figure status, because that's actually a big part of their argument. And I wish they would have flushed this out more. Looking at it now, in the briefing, in the initial briefs, I think this is important because part of the argument that the other side makes is that Vic admits to being a public figure in his pleading by stating that, well, he does this and this and this. But he can't admit to it. The court has to find it as a matter of law. So, thus, Vic's statement in his pleadings does not concede the issue that he is a public figure, nor could he have waived any objection thereto. Further, Marchi's evidence does not show that Vic was a limited purpose public figure. Marchi provides no evidence that people other than the immediate participants in this controversy are likely to feel the impact of its resolution, and that's citing WFAA-TV versus Macklemore. Moreover, the evidence clearly shows that Vic did not seek out this controversy. And here we start to see there are some issues in the footnotes with spacing. Again, these are not issues that are important to the court, but they're distracting and annoying. And if the court, here's the interesting thing about this brief. If the court shoots it back and says the table of authorities is wrong, they may have the option to correct form errors like the spacing issues in the footnotes. Having dealt with footnotes, I hate dealing with footnotes in Microsoft Word. I hate it with a passion. In fact, I hate most of Word's formatting stuff, especially for legal documents. It's not a great system. I mean, it's a nice word processor otherwise, but it kind of is shit at dealing with stuff like footnotes. Squally says, I'm crying. Please tell us more about how many fucks they are going to give this document, Nick. But legit, Vic was walking around Manhattan and no one knew who he was. No, of course not. Well, how would they? How would they know who he was? Okay. Marchi's argument fails to acknowledge the irrefutable fact that this controversy was forced upon Vic and not sought out by him. Marchi's statements on Twitter accusing Vic of sexual assault and misconduct cannot make Vic a public figure. In Wollston versus Reader's Digest Association, the United States Supreme Court stated, quote, a private individual is not automatically transformed into a public figure by becoming involved in or associated with a matter that attracts public attention. they have likely been drawn into a public forum against their will in order to attempt to obtain the only redress available to them or to defend themselves against actions by others. There is little reason. This is a long cite, but it's really a good one. There's little reason why individuals should substantially forfeit the degree of protection the law of defamation would afford them by virtue of being drawn in. That is a great citation on this issue, assuming, of course, that it's being legitimately quoted and it has not been subsequently overturned. This was decided in 1979. Vic testified, quote, "I did not ask for any of this. I was living my life and suddenly out of nowhere this stuff starts. I merely responded to it." There's no evidence suggesting that Vic in any way injected himself into this controversy. And again, one of the things that the court might have to deal with, or they cannot, and we'll talk about that when the time comes, they might have to deal with the fact that to suggest that Vic's very minimal participation makes him a limited purpose public figure because he merely responded to allegations made against him is to suggest that anybody who ever answers a public call against them is a limited purpose public figure. And that's a bit much for me. I don't know if it's as a bit much for you guys, but the idea that someone can say, "You're a rapist" on Twitter, you say, "No, actually, I never raped anyone. I hope no one ever felt pressured or anything by me like that." And then suddenly you're a limited purpose public figure, and now you have to prove actual malice in their comments. That's lunacy. That's lunacy. Okay, subheading B. Vic established by clear and specific evidence a prima facie case for the essential elements of his claims against Marchi, as well as the genuine issues of material fact therein. This is not part of the official TCPA issue. This is a summary judgment issue. However, I think what they're doing here is calling attention to the court that there are fact issues that are not resolved in favor of Vic. Kind of like they did a little bit in the Funimation brief. Let's see how they do it here. I'm not entirely sure. Vic met his burden of raising the existence of fact issues. Oh, there we go. Maybe this is part of it. In 2015, the Texas Supreme Court established that in order to succeed on an appeal seeking to reverse a trial court's dismissal of claims on a TCPA motion to dismiss, the appellant must meet its initial burden of raising the existence of a fact issue by competent evidence. Okay, so it's a different way to say prima facie evidence exists, but they're not only that they presented the prima facie evidence, but that prima facie evidence establishes or raises a fact issue. And this is borrowing, as the TCPA sometimes does, from the summary judgment idea. That you have to have a genuine... If both parties agree on the facts, then everything can be resolved as a matter of law. So if the parties disagree on the facts, on the material facts to the legal or to the application of law, then we need a fact finder. A jury or a judge in a trial setting is a fact finder. So this is a good citation as well. One that I'm not familiar with. So it's in Lipsky, but that's it's never been brought up in this way in the filings so far. In this regard, courts must accept as true all evidence favorable to the non-movement and must resolve all doubts and indulge every reasonable inference regarding the existence of a genuine issue of fact in favor of the non-movement. All right. Even if the trial court properly refused to consider Vic's second amended petition and its attachments, the trial court took all evidence offered into evidence by appellees into consideration. And this is probably where Chup, if this thing comes back on appeals, this is where Chup chupped it up for the defendants, and more importantly, where the defense teams chupped it up for themselves. No whiskey. Because If this comes back on appeals for this reason, that means that in their haste to disparage Vic in their pleading documents and in their filings on the motion documents, because if you remember those, they indulged themselves, and you can almost hear Lemoyne dying from a heart attack after masturbating furiously. You can almost hear that going on after they went through great pains to further defame Vic in their legal filings. So if they did that, then and the court determines that they raised the issues, then that's their problem. And it was a problem at the time. Their zeal may have done it, but we'll see. We'll see. Of course. Of course. This court must determine if Vic raised the existence of a fact issue within the evidence that the trial court did consider. Many genuine issues of fact exist within the evidence before the trial court, as shown by the conflicting arguments, assertions, and contentions made between Vic's brief and Marchi's brief, and their respective usages of the record in support thereof. A cursory reading of each brief's table of contents creates a reasonable inference that genuine issues of material fact exist, and pursuant to the above-referenced rule from the D Magazine Partners case, this court must indulge this reasonable inference that genuine issues of material fact exist in favor of Vic. Vic established by clear and specific evidence a prima facie case for his defamation claims against Marchi. This is one that I think is really important. This is the strongest case against Marchi, is the defamation claim, and I really do. I was in the courtroom. I listened to Judge Chupp question Sam Johnson about Marchi's tweet about Vic pulling her hair. I listened to that conversation. And then what I listened to in the next minutes was the most confusing courtroom shit I've ever listened to. Because Judge Chupp says to Sam Johnson, well, the idea of pulling her hair versus touching her hair is a fact question, isn't it? Sam Johnson says, well, yeah. And then he says, and whispering something into her ear, well, that's a fact question too, isn't it? Sam Johnson says, well, yes, it would be. And then Judge Chupp says to Ty, so where's the evidence that there's any issues of fact or defamatory statements at all? They were just talking about it. Like, they were just talking about it. So what Ty was apparently saying is, well, we've got the other tweet buyer, and Judge Chupp's like, no, I'm not interested in that. And he was just ignored the fact that he had a conversation about a tweet entered into evidence by both parties and said there were genuine fact questions in the defamatory tweet. Like, he had the conversation and then he just forgot that he had it. It was the weirdest. It was baffling. And then there was a brief recess. He said, okay, dismissed against Marchi. There was a brief recess, and Ty tried to bring that back up after the recess. Tried to say, there was the tweet about, the hair pulling and stuff like that. And the judge said, are you trying to go back to an issue I've already ruled on? He's very, very angry about that. It was very, very weird to see that happen in court, to play out where the judge literally forgot what he had just said. I don't know how else to describe it. It's just so damn strange. It's like, does he have anterograde amnesia? Like, what the hell happened? Felipe Move says, Nick, new lawyers don't have disabilities. They are just dumb. They got medals till 20th place, and now they say grammar is white supremacy. Well, grammar is white supremacy. I'm with that. Who wants grammar anymore? She just write all our documents on our phones. Ah, dang it. I'm not supposed to drink this yet. Okay. The Texas Supreme Court in Lipsky establishes that in a case of defamation implicating the TCPA, when the pleadings and evidence establish the facts of 1, when, where, and what was said, 2, the defamatory nature of the statements, and 3, how the statements damage the plaintiff, this sufficiently establishes a prima facie case for defamation by the clear and specific standard of evidence necessary to reverse a TCPA motion to dismiss. as I've said multiple times, defamation law used to be difficult because it was factually difficult to prove the transmission of a communication from the speaker to the listener. It's hard to say that someone said something audibly or passed them a note or a letter without somehow getting a hold of a recording of the conversation or a physical copy of the letter. When it's done on the internet in public, it's pretty easy to prove where, let's see, what was it? When, where, and what was said, right? Jamie Marchi published it at this time on Twitter, and she published this statement. When, where, and what are covered. So then all you have to do is talk about the defamatory nature of the statements. Saying that someone sexually assaulted you, or even non-sexually assaulted you, or committed sexual misconduct is defamatory if that's not true. And that was established. That was stated in the pleadings. That was stated in the courts. And how the statements damage the plaintiff, he goes ahead and points out all of the conventions that he lost, plus the damage to his reputation. Not to mention that this would be per se defamatory because accusations of sexual misconduct are per se defamatory, or of crimes. Assault is a crime. So either of those accusations are per se defamatory and damages are presumed, but he also mentioned the specific conventions that he lost because of it. All right. The record sufficiently establishes when, where, and what the defamatory statement said. Vic's defamation claim must include evidence that Marchi published a false statement of fact to a third party. All of the appellees offered sufficient evidence with their TCPA motions to meet this standard. So this is, they're going off the notion that even if you exclude Vic's pleadings, they offered the evidence in their own motion documents. Marchi offered her published defamatory tweets. Marchi did not deny in her TCPA motion to dismiss during the TCPA hearing, nor in her response, that she published a statement on February 8th, 2019 on Twitter, hereinafter February 8th tweet. She has not denied other statements she made about Vic on Twitter for other people to read. Marchi admitted her publication, content, and the surrounding circumstances of her defamatory statements. True. All very true. Marchi is again untruthful to this court when she states that the February 8th tweet does not reference Vic or what he did to Marchi. Marchi published Vic's name and accused him of assault in her statement attached to her TCPA motion to dismiss, but conveniently does not include her entire statement in her brief. Damn. Marchi admits the February 8th tweet is a statement of fact. So they're really trying to pin her down on this tweet. And that's important because it is the tweet. It's the tweet that matters. Marchi claims that Vic's defamation claim fails because it purportedly fails to provide the full context of the statement made in the undated tweet, and because it is not a statement of fact. In that tweet, Marchi stated Vic is a bad person. Marchi admits she published this statement about Vic. Marchi's statement within this tweet was published on Twitter on February 7th, 2019, to be read by the public to infer that Vic is a bad person, thus making this a fact statement. That sentence, I'm not... this is a... Without seeing the tweets in the citations, it's a little bit tough. I'm not sure exactly what these tweets are referencing, but I have to assume it's the hair pulling one. But she states that Vic is a bad person, thus making this a fact statement. I don't think it's making Vic being a bad person a fact statement. I think it's making the statement within this tweet was published on Twitter on February 7th. So it's like she quote tweeted herself or quoted a statement. I seem to remember that because her story was too long for 140 characters, right? So, but again, without seeing it specifically, it's kind of, it's weird to, it's hard to visualize exactly what that is. Although it's in her brief, I mean, I guess I could go find it. Page 13, never mind. I'm not going to go find it right now. As noted, Vic merely must show the existence of a fact issue within the evidence that was before the court for its consideration. Marchi's assertion that Vic's defamation claim fails because it purportedly fails to provide the full context of the statements made in the undated tweet is incorrect, because as previously mentioned, the evidence taken into consideration by the court included the entire record, save and except Vic's second amended petition and attachments thereto. I'm going to take a sip for that sentence because I'm still trying to noodle through what exactly is being said in this bad person sentence. But this part is solid. Actually, starting right here. This part of the paragraph is really solid because that's not the standard. So they're, for the purposes of this argument, foregoing the second amended petition and attachments. It's already in there. It's in her own brief and in her own pleadings. Marchi's assertion that Vic's claim should fail because he did not provide the full context of the undated tweet is not only nonsensical, but is dishonest, considering the evidence in her TCPA motion to dismiss. Marchi cannot claim that Vic's defamation claim in regard to the undated tweet should fail due to the court not having the full context of the statement made therein, when Marchi herself presented the full context of the undated tweet in an attachment to defendant Jamie Marchi's motion to dismiss pursuant to Texas Citizens Participation Act filed with the trial court on July 19, 2019. So she can't say that it wasn't before the court when she put it before the court. Furthermore, any, quote, statement is construed as a whole in light of the surrounding circumstances based upon how a person of ordinary intelligence would perceive it. Therefore, Marchi's statements about Vic must be viewed through the prism of how a person of ordinary intelligence would perceive each individual statement, not how an idiot like Jamie Marchi would. Vic's defamation claim evidence must establish that Marchi published a defamatory statement that referred to Vic, that Vic is, directly or indirectly, identified in Marchi's defamatory statement. Vic can show he was indirectly identified by the defamatory statement if those who know him and are acquainted with him understand that the statement refers to him. Additionally, it is not necessary that every listener understand the reference, as long as there are some who reasonably do. Marchi's defamatory statements in her February 7th tweet also refer to Vic. A statement can still defame Vic even if it makes no reference to him, as long as he is known and identifiable within his own community. He does not need to be known and identifiable within the entire forum through which the statement was published. Although Marchi's February 7th tweet does not refer to Vic by name, as her other two defamatory tweets did, the February 7th tweet still defames Vic, as evidenced by the replies to said tweet, which illustrate that the responders were aware that the tweet referred to Vic. So 71, that's in the record. Now, they have to have the replies in the record. I don't know. I'm not checking the record here. So I would assume that there are replies to the tweet in the record. Maybe that's a bad assumption. Marchi continues to intentionally mislead this honorable court in a response brief by stating that, quote, Vic expressly admits that the February 7th tweet does not reference him. To support this falsehood, she cites to the record at CR Volume 2, page 117 to 119. Only the last 5 lines of the cited text are relevant. Question. And my questions might sound familiar to you. Oh, this is Sam Johnson. The first one is your name stated in this tweet? No, sir. Is there any direct reference to you that you can see? No, sir. Nowhere in this text does Vic agree that the tweet is not in reference to him. That's true. He doesn't. In order to maintain his defamation claim, Vic must show evidence that the defamatory statement is false. Vic was not required at the TCPA hearing to prove Marchi's statements were false. That said, if the trial court incorrectly determined he was a limited purpose public figure, Vic had to show that Marchi's statements were false. He did so through his denial, which the trial court erroneously failed to accept as true. And that's, yes. Vic denied. He has a categorical denial of all of these accusations. And they're very happy to point to that apology, even though that apology contains a categorical denial of all of this stuff. There's a fact question there. All of this is false. He stated it in public. He stated it in his lawsuit. It was that statement has been introduced as evidence in the case. So now you have a fact issue. Any accusations of rape, sexual assault, sexual harassment, or pedophilia are 100% false. So now you've got a fact question that wasn't resolved in Vic's favor. Because if it was resolved in Vic's favor, that would say that the statement is false, that the accusation is false. Delth Walker says, Mama Bear said you have to stay out of Jamie's briefs, Nick. Ugh. I say if you aren't always, remember your safety gear, miner's helmet, non-slip, non-rust safety harness hooked up with a winch. Also, don't forget breathing apparatus. Also, cyanide pills. Don't forget the cyanide pills. Thank you for ruining my entire day with that super chat. That was disgusting. All right, now we've got a subheading. This one is not bolded. The other ones are... Part A is bolded. So I'm going to call that a formatting error. This should be bolded. I've also wanted to drink for a little while now. The record sufficiently establishes the defamatory... Oh, I should note, courts do not care about subheadings. They don't. The subheadings cannot be legally, like they're not legally operative. They're ignored in addressing things. It's merely a convenience. So criticizing a subheading is, again, when I point these things out, if these were defects that the court would care about, like I said, the table of contents and authorities, that's a defect the court may end up actually caring about. I will point it out. The other ones, just going to make fun of as they come up. Yeah, and the justification differences. Thank you for pointing that out. You can see that, and I think that's part of the problem with this document, is that it looks like it changed hands a bunch of times, and in changing the hands, it didn't get a uniform once over to fix the formatting issues. And because it's the last filed document, I would assume they were editing up until pretty much the last minute and ran out of time. That's my guess on that part. But, you know, sometimes that's how it goes in the legal world. And if you're writing your own documents, if you're a solo lawyer writing your own documents, it's much easier to track stuff like this than it is if you're passing it back and forth between people. But, you know, that's, like I said, it's not an excuse, because at the end of the day, this is what is filed and it gets to be made fun of. The evidence establishing the defamatory nature of the statement goes towards Vic's defamation claim, which is that in order for a statement to be defamatory, it must have been defamatory concerning the plaintiff. Marchi's defamatory tweets constitute libel per se, as they contain either references to false allegations and or direct accusations of sexual assault and sexual misconduct by Vic. These statements are libelous per se under both the statutory definition and also under the common law categories of defamatory speech, which imputes crime and imputes sexual misconduct. The evidence establishing the defamatory nature of the statement goes toward Vic's defamation claim, which is that with regard to the truth of the defamatory statement, Marchi acted negligently. I would say she acted with actual malice, with knowledge of the falsity, because she's talking about things that happened to her. Right? It's her personal experience. So if she's lying about them, that's not negligence. That's knowledge of the falsity. It also goes to the higher standard for actual malice in regards to the public figure doctrine. But, you know, that's my personal criticism there. Texas law dictates that negligence is the requisite degree of fault regarding the truth of the statement when plaintiff is a private individual. The defamatory statements made by Marchi were in reference to a conversation that only Marchi and Vic were privy to. As such, any evidence contrary to her statements logically and necessarily proves she knew of the falsity. Oh, here we go. and thus is sufficient, clear, and specific evidence that she made the defamatory statements negligently. No, with malice. That's not just negligence. That's actual malice. That is potentially a misstatement of the law there, because it's not negligence. Wait. I think I'm being too critical. It is still negligent if she knew the falsity, but it is also with sufficient malice. And they're talking about the negligence standard. So I think I was unfairly criticizing this thing. Let's see if they get to the actual malice part, because that's pretty important. Furthermore, in regard to the defamatory nature of Marchi's statements about Vic, Marchi repeatedly refused to acknowledge evidence presented by Vic which is to the contrary of the blatant falsifications of the record she represents to this court. But she also flagrantly ignores the evidence she herself presented to this court that directly contradicts the assertions in her response brief. Marchi admitted that she made accusations against Vic on Twitter to address him and the circumstances surrounding his alleged assault on her and his alleged history of sexual misconduct. Claims that her statements were made to protect herself and the public at large do not render her statements non-defamatory. That's true. They don't. Marchi's statements allege that Vic sexually assaulted her. Marchi admits she called Vic a predator in the same statement. The rational inference is that Marchi expected people to accept her statement about Vic as fact. Marchi tries to argue that Vic, quote, misstated the nature of her use of the word predator by a dubious and convoluted, that's a misspelling. That should be an O. Convoluted claim that because the tweet in question, quote, ends with a message to anyone who ever goes through a similar experience, it is purportedly a cautionary tale to anyone who, quote, had to experience what happened when they were unable to get out of Vic's grasp. Her use of the word predator therein was somehow not in reference to Vic, even though she said Vic specifically. Except that it was in reference to Vic. Yes, thank you. Thank you. Marchi cannot specifically tweet about Vic's purported assault on her and purported sexual misconduct, then shirk responsibility for calling him a sexual predator by ending with a self-serving reference to others who have had similar experiences with Vic or others. Sexual predator and sexual assault are clear, unequivocal terms that Marchi meant to be derogatory and to damage Vic's reputation, which is how a person of ordinary intelligence would likely perceive them. In addition, Texas law provides that accusations of sexual misconduct are defamation per se. All right. Lack of bolding continues. Woo. Okay. Is per se the same as pro se? No. All right. Subheading C, which is not bolded. Oh, which merits a sip. The record sufficiently establishes that the defamatory statements damage Vic, as well as the genuine issues of material fact therein. Vic's defamation claim also establishes that Vic suffered pecuniary injury as a result. Pecuniary is money. As a result of Marchi's false statement, unless injury can be presumed. What? That's weird. That shouldn't be an unless there, I don't think. Maybe I'm just reading it wrong. As discussed at length previously, if a defamatory statement constitutes libel per se, injury therefrom is presumed under the law. I mean, maybe they were going to write must establish and then changed it to also establishes. I think it does establish it, but this is just weird because this is right. The next section is right there. It's just a weird... That's a weird edit. In addition to injury being presumed, Vic has put forth a multitude of evidence from the record that sufficiently, clearly, and specifically establishes the damages to Vic that resulted from Marchi's publicizing defamatory statements about him. True. Look at this. This is, again, it looks like I wonder if this one... Yeah, it looks like this is a late edit because, like, look at the formatting difference. These look more like... Well, they're not full justified. They don't go... I don't know. Maybe not. Here I am delving into the weeds. Marchi's brief contains a section titled The Truth About Vic, which contains gross distortions of the truth and allegations substantiated by nothing more than highly contested, self-serving statements made by Marchi herself. Marchi alleges that, quote, rumors about Appellant had swirled in anime circles for years before Appellee Marchi's 2011 encounter with him. So much so that Appellant had a rumor panel at an anime convention years ago to address the various rumors plaguing him for much of his career. In support of this claim, hereinafter first allegation in Truth About Appellant section, Marchi cites to Clerk's Record Volume 2, pages 1000 and 1001, an excerpt from Vic's deposition. In reality, that excerpt reads as follows. Question. In the context of panel discussions at the cons that are, I guess, called rumor panels. Vic. No, sir. I did a panel many years ago at a convention about rumors about me because I wanted to dispel them. They were baseless and without substance, and I knew that people had questions. I wanted to address them. Is that the only rumor panel you've ever done? Yes, sir. Do you know what con that was at? No, not offhand. It was a long time ago. And what was the purpose of the rumor panel? As I said, I knew there were rumors and gossip online, and I knew that fans had questions about it, so I wanted to dispel the rumors. All right, I'll show you what we're going to mark as Exhibit 21. Oh, all right, I'll show you what we're going to mark as Exhibit 21. I'll represent to you Exhibit 21 is a post on the internet that I pulled off, or somebody pulled off, with a date of 4/20/2010. References a Takao Shokan rumor panel. Which is in Pittsburgh. Takao Shokan's in Pittsburgh. All right. Does that one refresh your recollection? That's what the rumor panel that you did was at Takao Shokan in Pittsburgh? Yes, sir. I suppose yes. I only did one. And I didn't remember the panel, the convention, and this says Takao Shokan, in which I know is a Pittsburgh convention, so I'm going to assume that's the one. Despite Marchi's claim that the citation supports prior allegations of sexual assault, the information contained in Exhibit 21 fails to raise any allegations of sexual misconduct or sexual assault against Vic. Oh, good point. That's interesting. So you did this rumor panel. They didn't say what rumors. They didn't ever establish what rumors they were. So that's good. She also cites to Clerk's Record Volume 2, page 947, paragraph 5, Declaration of Jamie Marchi. Paragraph 5 mentions nothing about rumor panels, rumors swirling, things plaguing him for much of his career. Paragraph 5 only deals with the February 8th, 2019 tweet, which calls Vic a predator and accuses him of sexually assaulting her. Damn. Marchi dishonestly tried to link a completely unrelated and irrelevant rumor panel to her own allegations of sexual misconduct by citing these two excerpts of the record in an attempt to fabricate a pattern of evidentiary support for her allegation that the various rumors about Appellant that had swirled in anime circles for years before her 2011 encounter with him had plagued him for much of his career. This misrepresentation of the facts in the record incontrovertibly show Marchi's calculated mendaciousness towards this honorable court. Marchi's first allegation in the Truth About Appellant section of her brief was undeniably deliberately drafted to deceive. And that is Again, these are bold accusations against Marchi and, more importantly, Sam Johnson. And Sam's drafting has largely been pretty clean. However, in criticizing Sam's drafting, I didn't actually match up the allegations. I take on faith that their citations are good. I take it on faith that the attorneys are not misrepresenting to the court. Also, tracking down every citation and showing them would be a large amount of time. It would be a very large amount of time. Marchi offers her own highly contested, self-serving statements to support her second allegation in the Truth About Appellant section of her brief, which states, quote, oh, I'll read it in Marchi's voice. At the beginning of 2019... Just kidding. Appellant's victims started speaking out about the pain appellant had wrought upon them. Seeing the hatred and shame appellant's followers attempted to hurl at appellant's victims online, appellee Marchi could no longer stay silent. I don't think staying silent is a problem that fat-ass Jamie Marchi has ever had in her entire life. Marchi's testimony is contradicted by Vic's evidence that until the defamatory and false accusations made by her, Rial, Toye, and Funimation, he had been employed as a voice actor at Funimation for many years, attended numerous conventions, and lived his life without controversy. Now, I'm going to point to the footnotes here because there's an issue going on here with the footnotes. There's one missing in 102. And this one is like, look, there's an extra period here. I don't know if there was a bad edit or if something got missed in converting it to a PDF, but there are issues with those footnotes. Again, fairly pointing out the issues with the document. Marchi's testimony is further plagued by her own evidentiary inaccuracies and circumstances tending to cast suspicion on the testimony, particularly her constant deceitful misrepresentation of the record. Oh, wait. Got a drink. Accordingly, because Marchi's evidence is disputed by Vic, the court must take Vic's dispute as true and thus deny Marchi's TCPA motion. And again, this is getting back to the crux of the argument. There are factual issues not resolved in favor of Vic in all of these cases. And those fact issues are raised by both Vic and the other parties. And the evidence supporting them, even if you strike all of Vic's evidence and ignore it, was raised by the other parties. The facts necessary to establish the prima facie showing. Importantly, even if the trial court could not consider Vic's affidavit and the other attachments to a second amended petition, the record still sufficiently establishes the required elements of Vic's claim and thus provides sufficient clear and specific evidence to the trial court as to each element of Vic's defamation claim. All right. Clear and specific evidence was before the court to support Vic's claim of tortious interference with existing contracts against Marchi. 1A, Marchi admits that the trial court could draw rational inferences from Vic's evidence. Really? Okay. Vic requested the court draw rational inferences from the evidence in the record. The trial court refused to consider the rational inference standard, indicating Vic was being held to a preponderance of the evidence standard, which violates the TCPA. And I agree. Chup did this, for sure. Chup did not, and Chup, I mentioned this last time, so I won't harp on it. Chup made a little funny joke, a little chuckle about Ty bringing up rational inference over and over. But rational inferences are part of the prima facie standard at the TCPA stage. That's from the case law. It's a quote from the text. That's why it was stated over and over again. And Chup refused to draw any inferences. And he said to Ty, you don't want a rational inference standard. You don't want any standard at all. and it was a nice little chuckle moment. But the problem was is that Chup was definitely ignoring rational inferences that could be drawn from all of these things. He just flat out didn't listen to it. Vic showed, one, that he had valid contracts with various conventions. Yes. Yes. By the way, it's in the pleadings that he had contracts with the named conventions that dropped him. It's in the pleadings. That said contracts were breached in association with Marchi's defamatory statements, that she willfully and intentionally interfered with those contracts, and that Marchi's interference caused him injury and actual loss of revenue. Marchi's knowledge and experience in attending the conventions gave her direct contact with convention organizers, provided her the appearance of credibility to allow interference with Vic's current convention contracts. Now, I'm going to be critical of this. This overall is a weak argument for TI, especially with existing contracts. This is a weak argument for TI because I don't know that they ever showed evidence that Marchi directly reached out and contacted one of these conventions. I don't know that they ever showed that in any way. The inference was that she might, based on her statements and her ability, whether or not that's sufficient, I'm going to hold off on that. My thoughts on Marchi on both TIs is that it falls under the auspices of the conspiracy and that she should go to trial on this stuff because of the conspiracy with Monica and Ron and other people discussing things, and that conspiracy opens her up to discovery to find out if she actually did contact any of these conventions. Whether or not she did, I don't know that they actually showed that. And I always thought that the TI against Marchi was a little bit weak. They're going to argue for it here, but I want to point out that I don't think that it's the most solid foundation. Contrary to Marchi's misrepresentations, Vic testified that conventions do not bring back the same guests each year, and Vic had not been banned from any convention prior to Marchi's defamatory statements. And that's true. No one has ever established that Vic was actually banned from a single convention. The only words stating that Vic was banned from any conventions were from the lunatic and certified idiot, Jennifer Lynn Cunt. That chick came out and said Vic was banned from TokoshoCon in like 2005. But then in 2006, Vic was at TokoshoCon the next year. And TokoshoCon or whatever, I think it was TokoshoCon, they never came out and actually said that he was banned. Nobody, in fact, has actually corroborated the idea of a ban. I believe actually the convention came out and said, we don't have any information about that because the records were destroyed or whatever. So there's no evidence of a ban. She then later said he was banned again. And it looks like he was just not attending the year she said he was banned and that he would attend like the next year. But since she's an absolute raving, frothing at the mouth, lunatic moron who should not be listened to for any factual assertions at all, as she is an admitted liar over and over and over again, and also has a disconnect with basic reality. This person is stupid and insane. I want to point that out. She, in her insane brain, decided that Vic's absence from a convention must mean that he was banned, rather than any evidence to support that he actually was banned. And there's evidence to contradict it because he came back the following years. That lady needs therapy and maybe some drugs or some ginseng or whatever to help her memory. Very stupid person. Clear and specific evidence was before the court to support Vic's claim of tortious interference with prospective business relations against Marchi. This is probably closer to a good argument than the existing contracts, just based on based on what was presented to the court. But I am going to take a sip for that unbolded subheading. Marchi admits that the trial court could draw rational inferences from Vic's evidence. Vic requested the court draw rational inferences from the evidence in the record, so it's very similar. The trial court refused to consider the rational inference standard, indicating Vic was being held to a preponderance of the evidence standard, which violates the TCPA. So it's the same argument here. Vic showed, 1, that he lost 7 to 8 roles as a voice actor in association with Marchi's defamatory statements, in which she willfully and intentionally interfered with those prospective roles, and that Marchi's interference caused him injury and actual loss of revenue. There is no B. There is no B, but Marchi. And to be fair, Marchi is a big enough B for all of us. Clear and specific evidence was brought before the court to support Vic's claim of civil conspiracy against Marchi. Okay, so then I got one more for this one. Consistent formatting issues are really tough on the drinking game. Now, this could probably be more fleshed out. It probably could be, but it's not. The frustrating part of it is that the word count. Like, this could probably be fleshed out a little more, but the word count. They're already pushing the word count. Maybe even too hard here. And we'll talk about that in a minute. Clear and specific evidence is a civil conspiracy. There were communications between Marchi and defendant Rial about Vic, which established civil conspiracy. Uh-oh. Is this a Discord or something? Vic has shown that Marchi was a member of a group of 2 or more persons with Rial, and the object of their defamatory statements was to destroy Vic's career as a voice actor. He demonstrated that they had a meeting of the minds on their course of action, as both have admitted. That's from the Marchi brief, the Rial brief. That's where I fucking said it. Despite their contentions that they were allegedly speaking on behalf of Vic's alleged victims, no such other alleged victims have spoken publicly accusing Vic of assault or of being a predator. That's true. That's true. In fact, again, the Yost twins and Sarah Breckmeyer appear to have been brought up by Marchi. And if you go watch, we haven't gotten to it yet in my Conversations by Proxy, but if you watch that Knucklehead stream, the Knucklehead stream, that is brought up, that it appears from all the evidence that Marchi, or that Monica raised all of the accusations to Funimation about the Yost twins and Sarah Breckmeyer, whatever her fucking name is. And Ron's face in that moment is priceless. It is priceless. Because it's this one. Shit, right? It's an oh shit face, and it's great. Sorry. Both allege Vic committed an assault against them, and because these statements are defamatory per se, damages are presumed. And that's a good way to lower word count, is to not have a space between words. Because Marchi's statements are defamation per se, and Vic has demonstrated conspiracy between defendants Marchi and Rial, his civil conspiracy claim against Marchi must be remanded. And I think it should. I think the civil conspiracy claim against Marchi should be remanded. I think the defamation claim, I think all of the claims should be remanded in light of the civil conspiracy claim. But I think the defamation claim is the strongest independent claim against Marchi. Vic sufficiently preserved objections to Marchi's evidence. Under the rules of evidence, a party may not challenge the admission of an exhibit on appeal unless he made a timely objection or motion to strike the evidence, stating the specific ground of objection if the specific ground is not apparent from the context. In paragraph 2 of Marchi's motion to dismiss pursuant to the Texas Citizens Participation Act, hereinafter Marchi's motion to dismiss, Marchi includes a chart of competent evidence upon which she relies in support of the motion. The chart includes 1. Declaration of Jamie Marchi. 2. Marchi's statement via Twitter. 3. Demand for preservation of electronically stored information. 4. Cease and desist retraction letter. And 5. Deposition of Victor Mignogna. Additionally, paragraph 2 states that Jamie incorporates and adopts by reference the evidence attached to defendant Funimation Production LLC's motion to dismiss under the TCPA and to defendants Monica Rial and Ronald Toye's motion to dismiss pursuant to the Texas Citizens Participation Act. So she listed the competent evidence that they wanted, and it's all included here. Let's see how they go to the objection. There's clear and unambiguous record of Vic's objection to all evidence Marchi included in support of her TCPA motion to dismiss. That's true. Vic clearly and unambiguously objected to the respective exhibits attached to Marchi's motion to dismiss upon filing Vic's objections and motions to strike with regard to Funimation's supplemental brief attached Exhibit D, Declaration of Jamie Marchi, Rial and Toye's TCPA motion to dismiss, attached deposition of Victor Mignogna, and additional exhibits attached thereto, including Marchi's statement via Twitter, demand for preservation of ESI and cease and desist retraction letter, Funimation's TCPA motion to dismiss, all evidence attached thereto, Rial and Toye's motion to dismiss pursuant to the TCPA, all evidence attached thereto. The evidence admitted at trial was insufficient. So he's saying that they do have the right to object to the evidence, or they did preserve the right to appeal on the evidentiary grounds because they preserved the objection. Okay, so that's all that section was for. Good job. The evidence admitted at trial was insufficient to establish appellee Marchi's affirmative defenses. Of course, Judge Chupp ignored their affirmative defenses on balance. He just didn't pay attention to them. Marchi failed to establish evidence supporting the affirmative defense of qualified privilege. The assertion that a defamatory statement was protected by a qualified privilege can only be properly asserted by meeting the requirements of such under either the common law standard or statutorily by meeting requirements of one of the specifically enumerated statutes that can potentially impart this privilege. To establish that Marchi is entitled to a common law qualified privilege, she must establish that each of her defamatory statements about Vic were 1. Made without actual malice, i.e. in good faith. 2. Concern a subject matter that is of sufficient interest to Marchi or be in reference to a duty she owes. And 3. Were communicated to another party having a corresponding interest or duty in relation to the specific assertions and allegations made therein. Now, of course, Marchi never said that she made the communication to a party. This would be like an HR person, right? The HR person has an interest in resolving something. They actually have a duty to address a concern. And so therefore the HR person would go ahead and they would ask questions of Marchi and she would provide answers, and those could be privileged, right? The HR questions and answers could be privileged if they're made without actual malice. She didn't make any statements to HR persons. She made her statements on Twitter. There isn't a privilege to communicating publicly on Twitter. That defeats the privilege. Alternatively, Marchi would have to establish that she meets the requirements of one of the specified statutes that potentially may impart a qualified immunity. The statutory qualified privileges that can potentially be asserted as a defense to defamation include certain privileges for print media defendants, broadcast media defendants, defendants on a medical peer review committee, expert physician panels and consultants, and employers insofar as the statements relate to a former or current employee's job performance to a prospective employer requesting such information. Despite attempting to assert this affirmative defense in her original answer, Marchi wholly fails to properly establish that she is properly entitled to a common law qualified privilege. In lieu of citing evidence in the record, in order to support her alleged privilege, Marchi merely makes conclusory assertions that, quote, any matters allegedly addressed were of public and or private concern and were made on the subject in which Marchi and recipients had an interest or duty. None of which is establishes you could tell they had is established and changed it to establishes. Changed it from a past tense to a present tense. None of which establishes any requisite element of common law qualified privilege, nor falls under any enumerated statutory privilege. Marchi published her defamatory statement on Twitter, a public worldwide social media site. She did not send said statement as a personal message to any Twitter user, nor did she tag anyone as being the intended recipient. Further, as mentioned above, the other person that the statement must have been communicated to must have had a corresponding interest or duty in relation to the specific assertions and allegations made therein. Nowhere else in the record or her pleadings is there any scintilla of evidence to support the idea that any other person had a corresponding interest or duty in relation to her defamatory statements relating to a conversation that occurred between no one other than herself and the Vic. The Vic! And the Vic! He needs to start referring to himself as the Vic. To claim otherwise is not only disingenuous, but is also a complete fabrication. An explanation of what privileged means here is needed. Okay. Privilege means you have a legal right to make a statement. Or legal privilege, I should say. And that privilege means that it cannot be a basis for liability in this situation. So a privileged defamatory statement. For example, if you make a false statement about a lawyer to the ethics board, for example, statements made to the ethics board are privileged, and a lawyer can't sue you for those false statements. Now, if there's actual malice or whatever, that may change the things. But if you just make a false statement about a lawyer to an ethics board, the lawyer can't sue you based on that. That's privileged. You have the privilege to make that statement in confidence. If I'm an employer and you are the former employer of someone and I call up and ask you for information about that employee, you can tell me that stuff because I requested it of you. Now, if you call me up, oh my goodness. If you call me up and say, hey, you don't want to hire this guy because of X, Y, and Z without my prompting, that's different. That's not qualified. The qualified privilege is I call you and I say, I understand X is a former employee of yours. Can you tell me about them? Oh, they're a drug dealer. Okay, that makes a big difference. I definitely want to hire them now. That's a qualified privilege statement at that point. So I hope that helps you understand what that is. Let's see. 2. Marchi failed to establish evidence supporting the affirmative defense that her defamatory statements were true or substantially true. Marchi's original answer makes no reference to any evidence in support of her claim of this affirmative defense. In fact, this section is literally only one sentence. Furthermore, the record and Marchi's pleadings, specifically her response brief, contain numerous blatant fabrications, falsehoods, gross mischaracterizations, and intentional deceptions that establish a pattern of Marchi's continual mendacity and complete absence of candor to this honorable court. In addition to all the instances mentioned thus far, it is important to note the utterly egregious subterfuge Marchi attempts in this section of her response brief entitled, Appellant Admits Under Oath to Assaulting Marchi. This is unequivocally and categorically an outright lie. Marchi cites generally to portions of the record containing her own declarations and Vic's deposition. In reality, Vic specifically took issue with Marchi's claim that he assaulted her by way of pulling her hair and emphatically states that such was not what occurred, nor did he have any intent to commit such an act. This is a great finish to the whole thing. This is a great finish to the whole thing. To leave it at that. She lied to you. Lied to the court. Conclusion and prayer. For the reasons stated herein, Vic respectfully requests this court reverse the ruling of the trial court and remand this letter for trial on the merits. And we have the certificate of compliance. Now, I will take a drink for the period, although the person doing this may just be European. But that is here, certificate of compliance, certificate of service. They said in the original, in the first filing, this was left blank. They caught it and refiled it 3 minutes later, still prior to midnight on the day with the actual thing. Lemons or whoever went ahead and released the documents initially just chose to ignore the fact that they had corrected that. And now, no idea why they would do that, but maybe it's because they're absolute giant gaping piles of garbage. Woo! So, that's the document. This document went much quicker than yesterday's document, and that's because a lot of the tangents that I would have done during yesterday's document, or during today's document, were done yesterday. I didn't think it was necessary to really tangent on all of them. This is a much more aggressive document than the Funimation document, and that's because you need to be aggressive to get past the multiple disgusting fat layers and lipid cells of Jamie Marchi. You've got to really get through that insulating layer of disgusting hairy fat that is stuck to her. Can we get a The Vic shirt on Teespring? Oh God, I don't know. I guess I could, right? Like, cause there you can't copyright The Vic, so I could probably do that. But people are asking me for like to go on and rant about public figures. Let me briefly address this. I think the public figure doctrine is one of the worst doctrines that exists. In regards to citizens, I agree with the public figure doctrine in regards to literal elected officials. People whose job it is to be public government agents. Not like a guy that's hired, not a cop, not some clerk at the records office, but like a senator, a congressman, the president, the governor, the mayor. That is the only public figure doctrine that should exist. Because we should have an unquestioned right to criticize those pieces of shit all day, every day, and not fear reprisal, because the reprisal comes from the state. That being said, the public figure doctrine being applied to Tom Cruise, it's just an easy example that I always go to. Tom Cruise it's a bullshit application of the law. What about Tom Cruise makes him somehow resistant to an allegation that you're not resistant to? Right? Look at Johnny Depp. Amber Heard fucking lied about Johnny Depp. Flat out. Bad lies. Tons of lies. Johnny Depp got canceled. Amber Heard, a shown and proven liar, a proven time and time again liar, has not been canceled yet. But Johnny Depp was. He may never recover. What special thing did Johnny Depp have that makes him, that as a public figure, he gets some special deference? He was canceled immediately. Think about this. Even if Vic was a public figure, the defamation destroyed his career in days. In days. What about Vic's status? Somehow insulated or immunized him from this. In fact, in a weird way, public figures are more likely to suffer damage from a false allegation than someone else. Because if you're not public, if you're just Joe, the cafeteria worker, and someone says and by the way, Joe said this racist thing on Monday, the cafeteria goes, hey, Joe, some guy's saying you're racist. That's weird. Why don't we call him an N-word? Right? Like they don't actually care as much because nobody knows who Joe is. So you can't go on Twitter and put pressure on the school system unless that person has already got some level of publicity. It's really fucking backwards. And it's because when this was created, when the public figure doctrine was established through the courts, it's not a statute, and it's certainly not in the Constitution that people would be treated unequally under the law. But when the public figure doctrine was created, people actually did have access to media that other people didn't. And their accusations came through the media. So if you go back to the days of, I don't know, who's old? Charlton Heston. You go back to Charlton Heston and you make an accusation about Charlton Heston, it's going to come, that accusation might come through the media. But if it doesn't, Charlton Heston is going to have a level of access to media that is beyond the normal person. So the normal accuser, they're on uneven grounds. Today, that's almost reversed. It's almost reversed. But here's the ultimate underlying question. Does the public figure doctrine violate the 14th and 5th Amendments of the United States, in which you are entitled to equal protection of the law by requiring that certain people have to defend themselves with an extra level of evidence that no one else needs to do? I think it absolutely violates those. Now, I'm sure there's court cases where the 4th and 15th, or where the 5th and 14th Amendment challenges to the public figure doctrine have been raised and they've been upheld as constitutional. But I think we need to reevaluate it again. Clarence Thomas agrees with me on that. It needs to be done. It needs to be done because there's no reason that Taylor Swift is somehow more immune to an accusation than you are. It's just not true. Or a lie, I should say. And she shouldn't have to go through and provide some additional level of evidence that you wouldn't be afforded to. I'm trying to come up with any sort of comparable thing, but it's just not for defamation, you know. If you say someone rapes babies, it's as bad. Like if you mean it, it's as bad. Like so-and-so literally raped a baby on this date. And that's as damaging to anybody. And there shouldn't be a difference of, well, you have to prove that he lied about it. Well, how the fuck do I prove that he's lying? Other than I didn't do it. That's a burden that shouldn't exist. But, you know, that's that. Simping for T-Swizzle the day before the Greer stream. You know, a couple years ago, I would simp for T-Swift all day. I would stand for her, or whatever you want to call it. Her new music, I like her old stuff. I don't like the pop stuff. Except for Style. That's a good song. Yeah, the Angry Joe situation, I am familiar with it. I plan to do, if I can muster it, a short video about his statement that he made. Today. I think it was a good statement. I think it was a good statement about, you know, he didn't have anything to do with it. He doesn't apologize. He gets a little bit preachy in it, but not too bad. And he doesn't capitulate. And that was good. It's a good statement. So I want to do a video about Angry Joe as well. But, you know, time of all this stuff. All right, guys. That's what I've got for the show. We've got a bunch of super chats to go through. And then I will take a short pause and go. We will be on the Twitch channel. We're going to end early tonight. I have no reason to carry on. I could ramble for another 30 minutes and then do the super chats. That wouldn't be very productive. We've been through the document. So I'm going to go on to Twitch. We're going to watch Hellraiser. And we're going to have a good time over there on Twitch. I strongly encourage you to come visit. I'm going to go try and convince Lady Rackets to come join us for Hellraiser as well. But let's do these super chats and then we'll get right into it. But Buddy69 says, I sent you a shirt for Drexel, although it somehow has my name on it, but your P.O. box. Allegedly, it's been delivered. Just wanted to see if it did make it or not. I'm sure Drexel will enjoy the shirt. Maybe have a live react of him opening it. I haven't gotten it yet. I'll have to check. I'll go check with my post office person. If it's got the wrong name on it, they may be holding it for a minute, but I'll go check on that. Felipe Move, thank you for the mask. Jay says in Lemoyne voice, here, far in Minnesota you are. I believe that the lung does go on. Once more, Nick opens the door, and Nick's here in my lung, and my lung will wheeze on and on. Nick can touch me one time and last for a lifetime. In the filings I do go on. Come on, guys. In Miss Piggy's voice. Come on now. Yes, I want his head. I want his balls. I want him to feel an ounce of the pain he's caused others and then fucking choke on it. I want you to take his dick out of your ears. Miss Piggy doesn't ever say this. And so you can actually hear reality. But you know, that's just me. Oh my god. But I know it's Yoda. Miss Piggy sounds like Yoda. I know. It's fucking difficult. Minecraft Jesus says, Nicholas, my son, hast thou seen thy proclamation of Talcum X, that mine visage is equivalent of white supremacy? Thou hast committed heresy against thy name, and a great punishment shall be delivered upon he. Upon his sermon, my visage shall topple upon him. Yes, I did see that, I did see that Talcum X, Sean King, is criticizing the white Jesus stained glasses that are out there. So that's very good. Goza, welcome to lawyer status. I appreciate it. Cabbage Head says, hey, Nick, Doug said you like super chats, so here you go. That's true. I do enjoy them. Looking forward to your Anime Matsuri panel. I'm working on a comic that I want to bring to Anime Matsuri next year. I want to hear all I can about storytelling. Sounds good. Kidda says, Meme Lord Carpe Donktum was punted from Twitter for repeated DMCAs. Cannot counter notify because they want him to dox himself to a third party. Hire a representative to do it. For the counter notifications, you can hire a representative to counter notify for you on your behalf. Laughing Carew says, yo, Nick, Keem won his case against Romeo. Shocking, I know. And I also knew. Thinking of making a show of it later with Peacock, maybe getting Keem on as well. I would love to talk to Keem. I assume the Keemstar will wait out approximately. First of all, the final resolution of the case is not done. He gets to go for fees now, which I'll cover on my short video. He gets to go for fees, but also I think he will want to wait past the appeal window before making too many public statements. But I will invite him on whenever he is ready to go. I would love to talk to Keem about it. JC Gaming says, sing in Lemoyne's voice. You spin me right round, like Corona baby right round. I hope that is what you were looking for. Skagi Onside says 720p with that nose, more like 720pp. Jonger Bongers has upgraded to super lawyer status. Thank you so much, Jonger Bongers. Etra Lobo Republic 1 says, yo, Nick, if you're looking for another game to stream either on Twitch or the other channel, definitely recommend Blasphemous. Classic Metroidvania with dark Christian overtones. Might like. I own it. I've never played it, but I own it. Macca Jr. says, do you like the Predator movies? And favorite one? Yes. Yes, I do. I mean, I have to go with Predator 1, but I like Predator 2 a lot. Drexel thinks Predator 1 is great and Predator 2 is garbage, but I think Predator 2 is campy enough to be hilarious. But one of those two. Probably Predator 1, but I like Predator 2. Macca Jr. says, Last of Us 2 can't be refunded in my city. Can't be refunded in a lot of cities, apparently. Charlie Spur says, don't we all want to hire Down syndrome lawyers? Charlie Spur says, Nick, your firm isn't diverse enough. Hire the disabled. No, I already have one disabled person at my firm. That's me. No one else needs to be, because I fall asleep in the middle of argument. Robonex666 says, Jamie Marchi is so fat her blood type is ragu. Damn. Robonex666 also says, how will they get Jamie in the courthouse if the trial resumes? Do they Crisco the door frames? They have extra wide doors and they have forklifts available. Fluffy Tet says, is Ty short for typo? In this document, I think so. Although Ty will never talk about this. But I do not believe that Ty had the final edit of this document. Remember, Ty was on my show when this document was filed. And I believe that its final revisions were done by the drafting lawyers, whoever that is. I don't know who ended up drafting any of the particular documents. But, he would take responsibility for the typos. But in reality, I think it was whoever filed it was the final person to touch it. And it looks like a lot of the errors came in a final edit. But I don't know. Macca Jr. says, Abby kills Joel. Ellie kills everyone but Abby. Thanks for the spoilers. Cemetery Lady says, is there going to be a watch party? If yes, what movie? Yes! Hellraiser 1. Hellraiser 1. Ben Frail says, always great to hear you tangent things, Nick. Hey, thanks. No one important says, Jamie is such an awful person. Quote, I wish that the worst possible non-lethal thing would happen to Jamie Marchi. Ron, hey, Jamie, can I stay with you? Damn. Don't do that to Jamie. Oh, God. Can you imagine the slappings? Estelle the Hispanic says, hey, Nick, did you hear Ron Jeremy is having a Me Too moment? He says that he has proof it's lies. About to be the most interesting Pornhub drop yet. Oh, my God. Don't make Drexel write more. Don't make him correct more often. Yeah, Ron Jeremy. That's... if there's ever anybody... All right, men. Have any of you ever gone far enough for a day? Right? Like, you've had enough for a day. Like, what you need at that point is a whiskey, a big ice pack, and like a TV. What was it? Al Pacino says this in Glengarry Glen Ross. He's like, imagine the best fuck you ever had. Wake up the next morning, your balls are like concrete. Right? Like, that's what he's talking about. You are spent for the day. My imagination is that that's Ron Jeremy literally constantly. That when he's not working, he's actively trying to avoid sexual encounters. That's I inherently disbelieve the idea that Ron Jeremy felt the need to rape anybody. But maybe I'm wrong. Maybe I'm wrong. Who knows? Interested to see how that's going. Andrew War Snowboard. I can feel it in the air tonight. Whoa. Oh my God. Angry Baneling says, hey, Nick, you guys saying it's a mental state or that it does not exist. I mean, okay. I'll defer to your wisdom. Angry Baneling says, hey, Nick, thanks for streaming. Please read the DMs I sent you. Really need to talk to you about some things. I'd appreciate that very much. I will, buddy. I will. Hildred Castagne says alcoholism is recognized disability. Bigots? Oh, what up, suckers? Gogger's death rattle. Continued as Lemoyne, you spin me. I want your lung. I love Adblock says hire Greer. Think of the funny Nick. I just have Russell do Russell, do my case selection for me. True SSJ Havoc says apparently Abby is a female. Regardless, she would be an example of woke SJW version of a woman. It's not a woman. I saw Neil Druckmann admit that Abby wasn't trans. That just means that Abby is a guy named Abby. Those shoulders are not feminine in any way. Not even close. Like you have to have, if you don't have a penis, you have to have one injected into your veins to have those kind of shoulders. Some nobody says Jamie Spagoo might turn Ron straight. Rip Monica. God damn it. Kermit the Frog says, hey now, comparing Miss Piggy to Jamie Marchi is a nasty insult to Miss Piggy. Yeah. I don't know how that's supposed to work. Master Yoda, God damn it. Racist, I am not. Hate everybody equally. I do. Yes. And then finally, Jonger Bonger says, where's my Discord invite? Jonger Bongers, there is a post on the community page that is only available to super lawyer level that will get you a Discord invite. You could just click it there and then you send your receipt or status or whatever to Snaj, the admin of the Discord. Or if you send me your info on Twitter, I can send you, or Twitter or email or whatever, I can send you the Discord invite. But it doesn't automatically go out. I haven't figured out a way to do that yet. But someone sent me something that I'm looking at that might work. Apollo 026 says, sorry, Nick, but the Ron Jeremy accusations are true. Really? I'm curious to see it. I don't understand. I don't understand when your job is having sex with people, why you would then need to have sex with someone else outside of the job. I'm not saying it doesn't happen, but seems pretty interesting, to say the least. So, all right, guys. That's what we have. Oh, that's weird. My video on The Last of Us 2 got age restricted now. It's age restricted. That's the video on the Rekieta Media channel. Now, interestingly, I had that thing reviewed specifically. I had it reviewed by a human, not by the algorithm. That's what took it so long to get up. And they didn't age restrict it. It just got age restricted after the fact by someone else. What the fuck? It's not listed as for kids. It's not listed as kids content in any way. But getting an age restriction, damn. So there you go. YouTube is against it. That is available on my Rekieta Media channel. You can still watch it. It's just, it'll have the age restriction thing. If you haven't put your age in on YouTube, you'll have to click on the disclaimer or whatever. And it won't distribute it out. That's just a man's chest. I don't know what they're talking about. So, all right, guys. I'm going to go see if I can convince Lady Rackets to join me for Hellraiser. We will be on, I will be on for sure Twitch as soon as possible. If I can get Lady Rackets on, maybe a few extra minutes. I believe she's still awake. And she said she would be interested if she's still awake and coming to watch. But I don't know if she's getting too tired. So I'm going to go check on that. And we're going to try and get her to the watch party, because I always enjoy watching shows with Lady Rackets. Oh my gosh. Oh, there we go. So, that being said, thank you for joining me tonight on YouTube here. And I will see you over on Twitch. I will see you on Heel versus Babyface tomorrow. Heel versus Babyface for a painting stream at noon. Discord, live chat Wednesday. If you want to join the Discord, $20 or it's a super lawyer tier here on YouTube, or the $5 plus tiers on Discord or Patreon. If you check Patreon and read the description of each one, they'll tell you the details between for live chat Wednesday, how that goes. Normally New Project 2 would be included, but without a payment processor, I'm not recommending New Project 2 right now. So if you want to join me, come join me for live chat Wednesday tomorrow. It will be after the Heel versus Babyface stream, which is allegedly will take place at 2 o'clock. And then at 10 p.m., an hour earlier than normal, 10 p.m. Central, will be the live stream of Russell Greer with Sriracha. Sriracha will be joining me for the Greer stream, 10 p.m. Central Time tomorrow. It's an hour earlier. Please come hang out. Sriracha is a funny lady and knows a lot about Russell Greer and his shenanigans. And we will be talking about his new lawsuit, his 4th lawsuit against Taylor Swift, which was just filed this year. So, as well as other stuff. All right, guys. Thanks for having me tonight. Thanks for joining me. And I will see you over on Twitch. Here's that outro. I should play that. We'll go ahead and hit that guy. Here we go. Here's the outro. I will see you in just a bit on the Twitch stream. Twitch.tv/Rekieta Law. We're watching Hellraiser tonight. If you have Amazon Prime. If you don't have Amazon Prime, but you have another way to watch Hellraiser, you can join us. It just won't be as smoothly integrated. But I will give a countdown so you can start Hellraiser at the same time that we do. All right, guys. Thanks a bunch. Have a good night. Peace. Peace.
We'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an art bag, a bow, more a love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all planet folk, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now.